Court of Tennessee is now in session.
Good afternoon, everyone. Welcome to our final case of the day on our Knoxville January 2022 docket. We appreciate the attorneys participating by Zoom. I understand that can be difficult at times. We appreciate your agreeing to do that. Welcome to all those watching by live stream on the court's YouTube channel. When we start, each side will have 30 minutes. If appellant wishes to reserve rebuttal time, please tell us that when you start your argument. Mr. Hivner, you may announce the case for this afternoon.
Recipient of final expunction order in McNairy County Circuit Court case number 3279 versus David B. Rausch, Director of the Tennessee Bureau of Investigation et al.
All right, thank you, Mr. Hivner. Mr. Horwitz, you may begin when you're ready.
Good afternoon, Your Honors. Daniel Horwitz of the Nashville Bar. I represent the appellant in this matter and the position that court orders are not recommendations, even for the TBI. I would like to reserve 5 minutes for rebuttal, please.
You may.
Your Honors, before getting into the merits of this case, I want to talk a little bit about why we are here today. And when I say why we are here, I don't mean procedurally. I mean the literal reason why I am speaking to the Supreme Court of Tennessee right now, rather than the director of the TBI. And the reason, of course, is that in this state, courts make judicial determinations and then parties and their privies are expected to comply with them, which brings us to the merits of this case, which are as follows. The TBI contends that it is a self-proclaimed judicial fail-safe against court orders that it thinks are wrong. The TBI also believes, and I'm quoting from the defendant's briefing here, that res judicata, finality, and contempt do not bear on the issue, and that none of these arguments matters where the TBI is concerned. As a result, the defendants remarkably insist that they have the authority to violate a final, unappealed, unappealable, and authentic court order that the state of Tennessee, which I will emphasize is the TBI's principle, entered by agreement. That order was then processed by every municipal, county, and state authority that received it, except for the TBI. Thereafter, the order was sent to the TBI in accordance with its ministerial duty under Tennessee Code Annotated Section 4032-102B to remove expunged records from the plaintiff's criminal history within 60 days. Upon receipt of the plaintiff's expungement order, the TBI also accepted and converted the plaintiff's $350 expungement fee. Thereafter, though, the TBI spent the ensuing 3 years willfully violating both the plaintiff's expungement order and the TBI's statutory obligation to process it, ultimately bringing us here. To be clear, the TBI has no such authority to violate or to sit in review of final judicial orders. The TBI is not a court. The TBI does not sit in review of courts. There is no TBI exception to this court's finality jurisprudence. There is no TBI exception to the doctrine of res judicata, and there is certainly no TBI exception to contempt. Nonetheless, the defendants will stand before you today and make clear in no uncertain terms that they are willfully violating a clear, specific, and unambiguous final court order that was never appealed and which the TBI never made any attempt to modify or reverse thereafter. Put another way, the TBI believes that this court's established rules of procedure, including all trial court litigation regarding expungement orders, the appellate process available to both parties thereafter, and Rule of Criminal Procedure 36.1 are for the little people. As for the TBI itself, the defendants believe that it does not matter whether an expungement has been ordered by a court or not. If the TBI thinks that the order is wrong on the merits, the defendants have made clear that they are not going to comply with it, regardless of whether or not the order has been appealed, modified, or reversed. Your Honors, I respect the sheer audacity of the defendant's claim in this respect, but it is a flagrantly contemptuous argument that would rightly subject any other lawyer to professional discipline and would land any other contemner in jail. It should be
Mr. Horwitz, this is Justice Lee. Let me ask you this question. The TBI cannot remove someone from the sexual offender registry if they've been convicted of certain offenses under 4039-207.
That's correct.
And with the effect of this expungement, also remove this defendant from the registry?
No, Your Honor. And let me be clear about this because respectfully, the defendant's briefing is misleading on the issue. The plaintiff is not on the sex offender registry. Let me say that again. The plaintiff is not on the sex offender registry. The plaintiff is not asked to be removed from the sex offender registry. The provision is completely irrelevant and the matter is a red herring.
All right, so let me ask you this as well. The state's position, and I'll ask Mr. Mitchell this as well. The state's position, I think, is that this defendant was convicted of an offense that disqualifies him from removal from the registry. But this is a motion for judgment on the pleadings. And in viewing your complaint, I see no indication of what he was convicted of and how that would support an exception or of him not being eligible for expungement or say release from the registry. So how is a sexual offense even part of this record for this defendant?
It's not. And
so how are we even talking about him not being eligible based on conviction of a sexual offense?
I don't think we should be. The problem is the trial court ruled against me in the matter. And I'm sure some of you are wondering or at least curious about what the plaintiff's expunged charges were. I have two answers for you regarding that, which are the only legally correct answers and the only answers that I can give you under the circumstances. The first answer is that the effect of expunging the records of a criminal charge is to restore the person to the position he or she occupied prior to the arrest or charge. Thus, persons whose records have been expunged may properly decline to reveal or acknowledge the existence of the charge. That comes from Pizzillo versus Pizzillo, which cites this court's decision in State versus Sims. So the answer to what the plaintiff's charges were is as follows. There are none. There is no sex or other offense because there is no offense at all. The plaintiff has been restored to the status that he occupied prior to his arrest, and he has a legal right not to acknowledge the existence of any charge whatsoever. The second answer is that you may safely conclude that the plaintiff and the state of Tennessee through a district attorney and the criminal court of McNairy County all concluded that the plaintiff was indeed entitled to expunge his charges under the relevant expungement statutes. I recognize that the TBI disagrees with the merits of that assessment, but the TBI is not a party to criminal proceedings. Similarly, if the state of Tennessee had believed that the plaintiff's charge was ineligible, then the time to raise that argument was in McNairy County Circuit Court 3 years ago.
Counsel, this is Justice Kirby. Let me ask you about some statutory provisions, please. Under 4039-207B, this says if a court of competent jurisdiction orders that an offender's records be expunged, the offense and the offense being expunged is an offense eligible for expunction, the TBI shall immediately remove the offender from the sex offender registry. So how does that contemplate? I mean, who is that directed at? That is directed at TBI, right?
Let me just emphasize this one more time. The plaintiff's claim for relief here has nothing to do with the sex offender registry. The plaintiff is not on the sex offender registry. The only provision that we're seeking relief regarding is the TBI's ministerial duty to process expungement orders.
Okay, fair. Let me ask you then about 4039-209, which says no record shall be removed from the sex offender registry unless ordered by a court of competent jurisdiction as part of an expungement order, so long as the offense is eligible for expunction. Is that also directed at the TBI?
It's certainly directed at the TBI, but again, if you're talking about removal from the sex offender registry, the relief is not at issue in this lawsuit. It is true, the TBI is correct that there are certain restrictions on expungement eligibility. That is a merits question. Here, there was an order, an expungement order, that resulted in a final judicial determination on the merits that the plaintiff, quote, is entitled to have all public records relating to the offenses listed above expunged. That's page 21 of the record. There was also exactly one opportunity to litigate the issue, and the McNairy County Circuit Court's merits ruling on it is final and preclusive. In other words, there's no way to re-litigate the question as to whether this was eligible or not, whether it was an ineligible offense as the TBI claims or not. The matter has already been settled. If state wanted to contest it, could have contested it, but certainly 3 years after the fact, an unappealed preclusive order is not the time to do it. Does that answer your question?
Mr. Horwitz, this is Justice Page. I'm a little bit confused by your argument here. I understand that your client was never on the sex offender registry because he was never convicted of anything. It was expunged, and conviction never went down under those circumstances. If you can't answer this, you can tell me that, but we're trying our best to keep this person's identity anonymous here. And are you telling the court that he was never in the trial court charged with a sexual offense?
That is not my position, Your Honor. My position is that he has no offense whatsoever and has been restored to the status that he occupied prior to the offense. He has a substantive right not to disclose the existence of any criminal charge. Does that answer your question?
I understand that, but there are, many offenses that are not eligible for expunction. But a person on the sex offender and a sexual offense is kind of a special category here. And I'm wondering, when we write this opinion, if we need to recognize that fact, if there's any reason for that.
There is no reason to recognize it, because the fact of the matter is that the claim for relief that we're seeking here has nothing to do with the sex offender registry. It's a separate statutory provision regarding.
It does have to do with whether it's a sex offense, though.
That's the TBI's position in this matter. That matter has already been adjudicated once. The eligibility was determined pursuant to a final court order on the merits that determined eligibility. I recognize that they say it's ineligible, but you get one bite at the apple here, not two.
Well, TBI, your position is that TBI cannot participate in the proceeding where that determination is made. So they're just a scribe. They have no authority at all. Is that your position, that they're just like a ministerial clerk who takes a record and puts it over here?
That's essentially correct, Your Honor. And let me emphasize the important textual provision here that leads to that conclusion. The statute at issue, Tennessee Code Annotated Section 4032-102B, provides verbatim as follows. The Tennessee Bureau of Investigation shall remove expunged records from the person's criminal history within 60 days from the date of receipt of the expunction order. The important thing to note about this statute is that a person's charges have already been ordered expunged by the time an expungement order reaches the TBI. Thus, the TBI's only role in this process is an administrative one, to remove records that have already been ordered expunged. In other words, the TBI doesn't adjudicate, they don't review, they don't expunge, they simply remove. But it's the order of expungement itself, not the administrative process of removing records, that confers legal rights and restores the person to the status that they occupied prior to an arrest or charge. For purposes of this case, that matters for two reasons. First, it makes clear, once again, that the TBI has no independent role in adjudicating expungement eligibility. That also should not come as a surprise to the TBI. As this court explained to the TBI just 2 years ago in State versus Allen, quote, "We also are unaware of any rule or precedent authorizing the criminal court to allow the TBI to intervene in either an open or closed criminal case." TBI apparently did not get the memo. I can only imagine that aggravates the court as much as it aggravates me.
Well, let me ask you a follow-up question, counsel. According to your argument, if I understand it correctly, if a court, in many situations, if a defendant is given a sentence that is illegal, he has the opportunity to contest that later under our rules. Under your argument, if expungement is wrongfully ordered, if a violent sex offender is inadvertently or for some other more nefarious reason ordered, if his records are ordered expunged, there is no recourse later. There is zero recourse for that decision to be revisited. If a defendant's sentence, if he feels that his sentence is illegal in some way, that can be contested under Rule 36.1. But I want to make sure I understand your argument. Your argument is that there is no recourse anywhere
No.
all right, then I want you to explain then
Sure.
why my statement is wrong.
As the Court of Criminal Appeals just explained, the remedy for an erroneous grant of expunction is through direct appeal. The state has a right to a direct appeal. The state also has a right under 36.1.
But also, according to you, TBI is not participating in those proceedings at all. They would have no reason to know until everything is over with and they get the expungement order. That's it.
The TBI does not play a role in this. Yes, you're correct. Just like any other non-party to a criminal case, the TBI has no role in this process. It's between the state of Tennessee and the defendant. So there is certainly ample opportunity for the state of Tennessee to remedy the circumstances that you're talking about, either by direct appeal, which is typically the proper mechanism, or via 36.1 if this is pursuant to an agreed sentence. But yeah, the TBI, just like the members of this court or anybody watching this proceeding, cannot jump into that proceeding and say this should never have happened.
Except that they are the party charged with doing the actual expungement. We are not.
By the time the TBI receives the order, that's correct. But I guess if the concern is that the state of Tennessee is going to be illicitly agreeing to expunctions and then not challenging them, then yes, I mean, there is finality accorded to court orders. And I don't know how to address the problem of a state of Tennessee through a district attorney doing improper things. But
Mr. Horowitz, this is Justice Bivens. There would be nothing wrong with the district attorney's office conferring with the TBI, much like it confers with local law enforcement agencies and prosecution or whatever, after the petition is filed, but before there's any action by the trial court, correct?
I think there would be no problem with that at all.
Mr. Horowitz, according to your brief, you're seeking, if we agree with your position, you're asking us to vacate the trial court order and remand this case for reconsideration. What would the trial court do on remand? If we agree with you that this is a final order and the TBI has to comply?
Sure. Turning to the specific question regarding which this court has granted review, right? This court is tasked with deciding under what circumstances, if any, the Tennessee Bureau of Investigation may refuse to comply with a final expungement order issued by a court of record. The answer to that question and what this court should hold is that there are only three narrow circumstances when the TBI may do so. First, when the order was issued by a court that lacked jurisdiction to issue it. Second, when the order was appealed or reversed through this court's established rules of procedure. And third and finally, when the order was procured by fraud. That's it. As the record of this case makes clear, the defendants admit that none of these three circumstances is present here. Instead, they insist that the TBI may refuse to comply with a final and unappealed expungement order simply because it thinks that the order is wrong. But that is not a circumstance that permits the TBI to refuse compliance. Additionally, for a wealth of reasons, the TBI's claim on the matter is not only meritless, it is lawless. The court should not tolerate it.
Mr. Horace, this is Justice Page. I have some empathy for the trial court here. And by the trial court, I mean the McNairy County Circuit Court. And I think you would agree with me that the order of expungement was in error. There was a statute that said, we think at the time that offense could not be expunged. The district attorney was apparently under the same misconception, or the assistant district attorney. I suspect they had an old criminal justice handbook in the courtroom or something, and nobody caught it. The one thing that really concerns me about this case, and I want you to tell me, I suspect the record is not developed enough, but my concern is at the time that the record was expunged, this offense was eligible. By the time the TBI looked at it 3 years later, the same offense was ineligible, because every time the legislature meets, those expungement statutes as to what criteria are available in each offense changes, right?
Your Honor,
I'm not sure that's really a question for you to answer, but I am concerned about that.
I would agree with you that the expungement statute is a mess and many portions of it are in conflict. I don't know that what you just said is the circumstances of what have occurred here, but I will say this, right? Because the answer is the same regardless. Res judicata serves as a complete bar to relitigation regardless of the merits of the claim. That comes from Creech versus Addington. The preclusive effect of the final order also applies to all issues which were or could have been litigated in the former suit. That comes from Massengill versus Scott. Put another way, as the Court of Appeals put it in 2015 in a case involving the TBI director himself, res judicata bars not only issues that were actually decided, but also those which could have been raised in the former suit. That's State Ex Rel. Johnson versus Gwynn. The doctrine also applies not only to parties, but to their privies as well. That's Rainbow Ridge Resort LLC versus Branch Banking and Trust Company, Tennessee Court of Appeals case out of 2016. Here, it is uncontested that the TBI is in privity with the state of Tennessee, which is the TBI's principle as to the plaintiff's expungement order. With this context in mind, all issues regarding the plaintiff's expungement order, including the plaintiff's underlying expungement eligibility under the applicable statutes, were conclusively settled by the McNairy County Circuit Court's merits ruling once it became final. That's Davis versus Williams, Tennessee Court of Appeals case from 2011. And that's the rub here. The defendants have argued throughout this proceeding, and I'm quoting directly from the defendant's own briefing at page 149 of the record below, quote, "The merits of the underlying expunction order must be revisited in this dispute." That's their position, and it conflicts with every decision this court has ever issued on the doctrine of res judicata in its entire history. The effect of this court's precedent is clear. Whether or not the TBI believes that the plaintiff's expungement order was correct, the order is no longer subject to any relitigation. Thus, by willfully violating the order, the defendants are acting in contempt of it. That's what this court's opinion should say, that none of the three narrow circumstances that permit the TBI to resist an expungement order is present here, that res judicata bars any and all relitigation over the merits of the order, and that by willfully violating the order, the defendants are in contempt of it.
Mr. Horowitz, we're not here to decide a contempt petition. We're here
No.
to decide what the merits of this claim are.
That's correct, Your Honor. The question.
Let's move on to that.
So moving on to that, the question is when courts or when the TBI may resist a final expungement order. I'd submit that it overlaps with this court's contempt jurisprudence, even though this court is not deciding contempt. You're right. Turning to the first circumstance that permits the TBI to resist a final expungement order. A lack of jurisdiction is a defect that precludes an order from being lawful. We get that from a contempt case, Konvalinka versus Chattanooga Hamilton County Hospital Authority, where this court held that a lawful order is one issued by a court with jurisdiction over both the subject matter of the case and the parties. Thus, the TBI may resist an expungement order that was issued by a court without jurisdiction to issue it. So, for example, if the Supreme Court of Afghanistan ordered the TBI to expunge a criminal record, the TBI would not have to comply with that order. Given this context, the question becomes what courts have subject matter jurisdiction to issue expungement orders? And that question is easily answered by reference to Tennessee's expungement statute, and it was recently answered by the Court of Criminal Appeals in State versus Brown, where the court explained that our legislature has granted jurisdiction over petitions for expungement to the criminal court that adjudicated a petitioner's charges. Fortunately for the plaintiff, the criminal court that adjudicated his criminal charges is also the same court that entered the expungement order regarding them. Thus, the fact that the plaintiff's expungement order was issued by a court with jurisdiction to issue it is uncontested in this case. Because the relevant criminal court also has exclusive jurisdiction to adjudicate expungement petitions, that fact alone also precludes the TBI's entire position in this case, given that the TBI has no judicial authority or jurisdiction of its own to make expungement determinations. Turning to the second circumstance that permits the TBI to resist a final expungement order, if the order is successfully appealed or otherwise reversed through this court's established rules of procedure, then the TBI does not have to comply with it. Once again, as the Court of Criminal Appeals recently explained in State versus Brown, the remedy for an erroneous grant of expunction is properly sought by direct appeal. And while Rule 36.1 may similarly enable a challenge to an expungement order under circumstances when it is made part of an agreed sentence, the ultimate point is this. With the approval of the General Assembly, this court has promulgated specific rules of procedure for contesting assertedly erroneous expungement orders. Those rules matter. The TBI also cannot opt itself out of them simply because it believes that it is some kind of special litigant or superior court that is exempt from the same rules that apply to everybody else.
Mr. Horwitz, exactly how would the TBI have appealed this expungement order? It wasn't a party to the case.
Your Honor, I've thought about this a lot. So I guess first I will flag the fact that TBI did not even attempt to intervene, did not
Right.
attempt to modify this, made no effort. I think, I don't know because it hasn't been presented, but I think the certiorari statute may give an affected litigant like the TBI the opportunity to participate here. Certainly the state of Tennessee, which is the TBI's principal, can exercise rights as a party. But here, this is 3 years out. Nobody appealed. Nobody made any effort to appeal, to intervene, to bring the matter to review by certiorari. I think the Court of Criminal Appeals narrowly concluded that only direct appeal is the way that this could be reversed. But the answer to your question, Your Honor, is nobody even tried. The TBI just received this order, took the plaintiff's money, and then decided not to comply with the order at all. As a result, the order has been final for nearly 3 years at this point, and certainly now, no court has any further jurisdiction to disturb it. I see that my time has run out.
Thank you, Mr. Horwitz. Mr. Mitchell.
Good afternoon, and may it please the court. My name is Rob Mitchell, and I'm here on behalf of the defendants appellees, the Tennessee Bureau of Investigation, and its director, David Rausch. This court should reverse the Chancery Court's ruling on subject matter jurisdiction and vacate the order on the motion for judgment on the pleadings and thus dismiss count 1. Or in the alternative, this court should affirm the Chancery Court's ruling that defendants, the TBI and Director Rausch, are statutorily prohibited from expunging records of sexual offenses, even if the offender received judicial diversion.
Well, Mr. Mitchell, how is a sexual offense in this record? How could we rule on the second basis based on this record?
So the Chancery Court addressed this, and we did file a motion to file a less redacted copy of the expunction order under seal, which the Chancery Court denied during the cross motions for partial judgment on the pleadings. We pointed to, Your Honor, it's the third exhibit to plaintiff's complaint in which a attorney general points out that the basis for TBI's refusal to expunge the records is the provision in the expunction statute saying that sexual and violent sexual offenses are ineligible for expunction. That was as far as the case developed.
That's not a very strong basis, is it? I mean, I'm just wondering, this is here on judgment on the pleadings, and I'm just not seeing anything in this pleading that points to a sexual offense. And I guess I'm just having trouble with that part of the record. Do you think that's an issue?
It's an issue under the Chancery Court's finding, and that's why the Chancery Court couldn't rule for either side. And of course, the Chancery Court did note that we had pled it as an affirmative defense that the offense at issue was a sexual offense. But yes, that does at this stage present an issue. I'd like to begin by addressing the subject matter jurisdiction of count 1, because under count 1, defendants are immune from suit because the General Assembly has not waived the state of Tennessee's sovereign immunity under count 113-121, which is the statute that plaintiff proceeds under. As Your Honors know, subject matter jurisdiction is a threshold issue that can be raised at any time before any court, and sovereign immunity is a jurisdictional bar to an action against the state of Tennessee. And so in order to waive sovereign immunity, a statute has to contain a waiver that has 3 requirements. First, it has to be plain, clear, and unmistakable. Second, that statutory waiver has to be explicit, not implicit. And third, that statutory waiver has to clearly and unmistakably express the General Assembly's intent to permit claims against the state of Tennessee. Nothing in count 1, the count we're here on today, explicitly and unmistakably expresses the General Assembly's intent to permit claims against the state.
Well, under 1-3-121, this petitioner would be an affected person. This petitioner seeks declaratory or injunctive relief, and it's regarding the legality of a government action. Why doesn't that fit precisely under 1-3-121?
So you're right, Your Honor. The General Assembly in other contexts knows how to specify the state of Tennessee when it clearly, unmistakably, and explicitly intends to waive the state of Tennessee's governmental immunity. For instance, as we point out in our brief, in the Uniformed Services Employment and Reemployment Rights Act, the General Assembly not only said governmental agency, but it also said Department of State Government and autonomous state agency, therefore adding additional specification that is missing from the count that we have here. And so it's for that reason, because it's not clear and unmistakable expression of the General Assembly's intent to permit claims against the state, that sovereign immunity has not been abrogated on this claim and therefore is a jurisdictional bar to this count.
So,
But
so what could 1-3-121 mean if not that you could sue the government about the legality of a government action if you're affected by that?
it could address actions of other governmental agencies, counties, municipalities.
You're saying it has to specifically say the TBI?
No, but it does need to specifically say the state or the state of Tennessee. I'm not sure there's any
Well,
talent
is the
in it.
TBI not an agency of state government?
It is. It is an agency of state government.
Then how does this statute not apply?
The statute doesn't say the state. It just says governmental action.
Well, in the state, the government,
Who else is taking governmental action besides state and governmental entities?
It could be a county. It could be a municipality.
Well, exactly, but they're still a part of a governmental entity. The state is also a governmental entity.
Correct, Your Honor. The state is a governmental entity, but it's not. The statute doesn't clearly, unmistakably express the General Assembly's intent to waive the state's sovereign immunity here. And so for that reason, the sovereign immunity wasn't waived for purposes of this count.
is there anything in the legislative history that would clear that up?
None that I'm aware of or that we've pointed to our brief, Your Honor.
Okay, thank you.
Mr. Mitchell, this is Justice Page. To go back to the other issue, is there any statute or any other provision that makes what the TBI has to do under these statutes we're talking about anything other than a ministerial function?
Under the four statutes that we've relied on our complaint, Your Honor, first there's the expunction order that's entered, and then TBI does have to determine the eligibility under both the removal of records statute, which would be section 209, and then the removal of offender statute, section 207. So TBI is tasked by the General Assembly once an expunction order is entered with confirming and determining that that offense is in fact eligible for expunction under the expunction statute. But no,
is
other
there
than those.
is there anything that gives them any discretion to fail to follow a final court order of a court of record that had authority to make that order and it wasn't procured under fraud and all the things Mr. Horwitz went over that would be exceptions?
Well, so that court order, Your Honor, has to be harmonized with the TBI statutory duties. And after all, it's the General Assembly that gives both the McNairy County Circuit Court the power to enter expunction orders and also TBI the power to process them and comply with them in accordance with those orders. And so reading those together, you have TBI's general duties under the expunction statute when an expunction statute or expunction order is entered, excuse me. And then you have TBI's specific responsibilities that, as the Chancery Court acknowledged, only come into play once an expunction order is entered. And so the expunction order is kind of a condition precedent to TBI's duties to review the eligibility for expunction of records being triggered.
You do agree that TBI...
Let me ask you then, so you're in essence saying that statutes require the TBI to review this and look at that. Okay, let's assume for a second, even assuming for a second that's correct. Local agencies and law enforcement agencies have duties under statutes as well and have an obligation to review things of that nature. But there seems to be little argument that the courts are the ultimate determinator, make the ultimate determination of whether the actions by those law enforcement agencies are correct or not. So why is it different for TBI versus the other law enforcement agencies?
It's different for TBI because of these two specific statutory provisions that affect just certain types of offenses, not any offenses, but sexual and violent sexual offenses. And again, this is sections 207 and 209, the removal of records and removal of offender statutes. That's what makes this such a narrow carve out, as the Chancery Court acknowledged, is this additional language that is distinctly allocated to TBI to see that the offense, so long as the offense is eligible for expunction.
But to interpret those provisions the way you do so, does that not then put us right in the middle of the separation of powers question?
It doesn't, Your Honor. As I said a second ago, because the General Assembly granted the authority both to the court that entered the expunction order and also the TBI, TBI is complying with the order to the extent it's authorized to under its statutory responsibilities as found in these two removal of records and removal of offender
But the
statutes.
TBI is a part of the executive branch, correct?
Yes,
And the judiciary is a part of the judicial branch.
yes, Your Honor.
Mr. Mitchell, I find it very concerning that an assistant attorney general would tell a state agency to ignore a final court order. Do you see any problem with that?
Your Honor, TBI is not attempting to ignore the court order. It is trying to comply with the court order to the extent that it can under its statutory responsibilities that have been laid out by the General Assembly. And so I recognize Your Honor's apprehension, but TBI has these specific duties that it's been tasked with by the General Assembly. And so it receives a court order after that court order has been entered. Under this court's jurisprudence, as Mr. Horwitz pointed out 2 years ago, TBI has no authority to intervene in that open or closed criminal case in which the expunction order was entered. And so TBI is left to wait and receive that expunction order. And then pursuant to what the General Assembly has said, that's a condition precedent to reviewing the expunction order for eligibility for expunction. And so TBI is just trying to comply with the expunction order and what the General Assembly has.
This is Justice Bivens again. Kind of the same question I asked Mr. Horwitz. What would prohibit the district attorney's office, the local district attorney's office, who are handling the petition for expunction, to consult with the TBI during that process instead of waiting until after the fact and therefore allow TBI to have input at that point in time into the process as to whether it's valid under the statute or not?
I'm aware of nothing that would prohibit that, and that sounds like a great suggestion, Your Honor. I think that would be best practices.
Well, and doesn't that avoid any constitutional separation of powers issues?
I think it would, yes.
And
Go ahead, Justice Lee.
well, Mr. Mitchell, if we agree with your position, where does that leave a defendant who has successfully entered into a diversion agreement, who has completed 4 years of probation, who has paid his money, filed his petition, got an order of expungement? Then the TBI says, we don't like that order. We're not going to remove your records. What recourse does this defendant have?
If this court agrees that TBI is prohibited from expunging these records, then under that reading, the offense was not eligible for expunction to begin with, and the defendant has already.
So the defendant has no recourse, subject solely to what the TBI decides about the order.
No recourse, although the defendant could, of course, go back to McNairy County and seek contempt if the defendant thought that TBI had acted wrongly.
Okay. No, I think has a question.
Is there a method, Mr. Mitchell, for TBI to have, rather than simply refusing to comply with the order, to have collaterally attacked it, brought it to the courts in some way? Is there a mechanism for that?
None that I am aware of, Your Honor. Under the expunction statute, the order just has to be sent to TBI within 30 days. And of course, that order can become final within 30 days. And so we're stuck with a situation where under this court's jurisprudence, the Allen case that Mr. Ford cited, the TBI can't intervene, can't do anything to seek to modify an open or closed criminal case. And then on the other hand, there's this time constraint on the order doesn't have to be sent to TBI until 30 days. And of course, then TBI would have to review it and figure out what could be done. And so no, Your Honor, there is no recourse. And in any event, we disagree with Mr. Horwitz's position that the order is res judicata against the TBI and that the parties are in privity. I mean, of course, the TBI is the state of Tennessee, but as this court knows, privity centers on an identity of interest, not the legal relationship between the parties themselves. And privity is fact specific to each case. So TBI has these specific, distinct responsibilities under the removal of offender and removal of records statutes regarding what records TBI is authorized by the General Assembly to expunge once an expunction order is entered. And those responsibilities are distinct from any other responsibilities of any other state of Tennessee agency, including a district attorney's office.
Mr. Mitchell, this is Justice Page. If the statute were amended and stated that the petition for expunction would be served on the TBI during the trial court proceedings, would that solve our problem?
Hopefully, Your Honor, it would certainly go a long way towards solving the problem, and it should solve the problem. Yes, and I think that, as I'm sure Your Honor is aware, the DAs have 60 days to respond to the petition. Right. So that would also, build in some adequate time.
One concern I have with your petition, 4032-101G8, it entitles that petitioner to take a copy of his or her expunction order, and it says it shall be sufficient proof that the person named in the order is no longer under any disability, disqualification, or other adverse consequences resulting from the expunged conviction. I can think of all sorts of scenarios. A person can apply for a job, attempt to become a school teacher, register to vote, try to join the military. There are just many things. And then 2 or 3 years later, people come back and say, well, you lied to us. I mean, based on your position here, how's that to be avoided?
Well, hopefully one, this is a narrow carve out. And so this only applies to Tennessee offenses for which someone received judicial diversion and then subsequently an expunction order. TBI.
So being a narrow carve out doesn't help the individual I just hypothesized about, does it?
It doesn't help the individual you hypothesized about, no, Your Honor. But if TBI was right in relying on the removal of records and removal of offender statutes, then the offenses would have been sexual or violent sexual offenses that weren't eligible for expunction anyway. So reading the expunction statute, the diversion statute, and then those other 2 statutes all in harmony, this is a situation that shouldn't ever occur. And so any relief anyone receives, such as your hypothetical individual, would be more than it sounds like that individual is entitled to under any of those 4 statutes, much less all of them read in harmony together. I would like to point to, as we pointed out in our brief, to the legislative history of the removal of records and removal of offender statutes that are contained within the Sexual Offender Registration, Verification, and Tracking Act. In 2008 is when the legislature added what we contend is critical language. First, to Section 209, the Removal of Records Act, the legislature added the so long as language, the language that the language that modifies the receipt of an expunction order and then removing those records so long as the offense is eligible for expunction. Similarly, that same year, 2008, the legislature added language to Section 207, the removal of offender statute, which is not just TBI receives an expunction order, but also the offense being expunged is eligible for expunction under the expunction statute language. And so the General Assembly in 2008 addressed the possibility that an expunction order would be entered for an offense that is not eligible for expunction and expressly added that language as a condition precedent, which is what the Chancery Court called it, a condition precedent to TBI's removal of these records. And so it's based on these 4 statutes, especially the removal of records and removal of offender statutes, the Chancery Court correctly concluded TBI has to determine whether an offense is eligible for expungement under 4032-101 before the TBI removes those records.
Does it, Mr. Mitchell, does it make any difference at all that your opposing counsel makes the point that this defendant was not on the sex offender registry? Does that make any difference to your argument?
Your Honor, and I want to be very careful here, there has not been evidence in the record whether plaintiff was ever on the Tennessee sexual offender registry. And I want to be careful about terminology when I address that, because SOR is a statutorily defined term in the Sexual Offender Registration and Verification Tracking Act. And SOR is the TBI's centralized database for what we colloquially refer to as the sex offender registry. And so SOR.
We would know more about that had the trial court granted your motion to put that information into the record. Is that correct?
Correct, Your Honor. And depending on the posture of this case and what happens here, that may be a fact that's subsequently developed. But SOR, where it's a defined term, refers to the database. And so when we talk about whether someone's on the registry or not, I just want to make sure we're careful about that language. And I'm sorry.
Mr. Mitchell, this kind of goes back to one of my earlier questions. To agree with your position, do we have to assume that there was an underlying conviction here for a sex offense that was ineligible for expungement?
No, Your Honor, you do not, because the Chancery Court did not determine that. The Chancery Court found that was a disputed fact, and that was the basis upon which the Chancery Court denied both cross motions for judgment on the pleadings. So to affirm the Chancery Court's ruling and agree with the Chancery Court that there's a narrow carve out, that fact does not have to be determined at this stage. It'd be subsequently determined if, for instance, a lesser redacted copy of the expunction order was filed.
Isn't that sort of an advisory opinion? Aren't we issuing an opinion on facts that are not proven or may not exist? I mean, why would we issue an advisory opinion based on a sex offense that may or may not exist, and certainly may not exist if this expungement order is valid? I'm just having trouble understanding how the record allows us to rule in your favor.
I don't think it would be an advisory opinion, Your Honor, because even though this case is before this court on an interlocutory appeal, and on the question of what circumstances TBI can refuse to, if any, comply with a court order, the issue is these cross motions for judgment on the pleadings. And so since the Chancery Court found that defendants pled the affirmative defense that there's a sexual offense and denied defendants' motion for judgment on the pleadings and also denied plaintiff's motion for judgment on the pleadings, this court could affirm the Chancery Court's analysis without deciding that issue and basically just affirm and ratify the Chancery Court's statutory interpretation of these different statutes that are all at play in this case. And then, of course, that fact would be plugged in subsequently if the Chancery Court had subject matter jurisdiction.
And I did not see that pled as an affirmative defense, but I'll go back and review the answer again.
And Your Honor, just to be very clear on that, what the Chancery Court found was that defendants didn't explicitly use the term affirmative defense, but right. I believe it's footnote 4 of the court's order. It noted at least 7 different paragraphs in which defendants had made denials in their answer. And the court said that those denials amounted to pleading an affirmative defense.
Mr. Mitchell, this is Justice Page. We've been talking about a conviction or pseudo conviction, whatever, but I'm assuming that this case took place like every other deferred probation case. There was an order of deferred probation entered and defendant was never convicted of anything. He stayed on probation 4 years and then his expungement was granted. And there was never an order of conviction, never a judgment, right?
Correct, Your Honor. And so the judicial diversion statute, as this court's aware, the expunction statute, and then these other 2 removal of records and removal of offender statutes all incorporate and reference one another. And although under the Sex Offender Registry Act, a diverted offense or a plea entered pursuant to 4035-313 can constitute a conviction, that's not necessary to the analysis here. A judicially diverted offense can still be expunged. And nonetheless, if the offense was a sexual or violent sexual offense under the expunction statute, the diversion statute also says this, and then of course these 2 other statutes, if the judicially diverted offense was a sexual or violent sexual offense, then it's not eligible for expungement. So regardless of whether we use the term judicially diverted or conviction, it shouldn't affect or doesn't need to affect the analysis here.
There's no rule, Mr. Mitchell, that you have to use all of your time. It's okay.
Well, if there's no further questions, then for the reasons stated, we would ask this court to reverse the Chancery Court's ruling on subject matter jurisdiction and find that Chancery Court lacked subject matter jurisdiction over count one, or in the alternative, affirm the Chancery Court's analysis of count one. Thank you.
Thank you. Mr. Horowitz?
Your Honor, I've got plenty of things, so I'm going to try to speak quickly. I apologize. First, they did not plead it as an affirmative defense. They simply didn't. You can review their answer. It's not there. Second, the Chancery Court determined that it had subject matter jurisdiction under 13121. The defendants did not seek interlocutory review of that order. That's the end of that inquiry if you want it to be. There are actual rules for seeking interlocutory adjudication, and they simply have not complied with them, just like they have not complied with the
counsel, don't you, that subject matter jurisdiction is always an issue, whether it has been raised below or not.
Always an issue, but adjudicated.
Surely you know that.
Yes, but it has been adjudicated below, not simply raised. It can be raised again in the normal appellate course. Justice Lee, you are correct. The AG's office has advised the TBI not to comply with this court order. It is enormously problematic. Turning to the trial court's contrary ruling, I will address it briefly because the defendants do not actually defend what the trial court ruled. In its order set forth at page 341 of the record, trial court held that if the TBI concludes that the offense is not eligible for expunction, the party seeking expunction is given due process under section 4039-207 G1 to contest the TBI's determination. Your Honors, this is completely wrong. Merely reading section 4039-207 G1 reveals as much. That statute provides that an offender whose request for termination of registration requirements is denied by a TBI official may petition for review of that decision. Provision has nothing whatsoever to do with expungement determinations. It is just a request for termination of sex offender registration requirements, which is a separate issue. Justice Page, I also want to emphasize that the TBI's position in this case is completely untenable as a practical matter. You cannot have two different sets of official conflicting criminal records. To illustrate why, I want to use a felony conviction as an example. If a criminal court orders a felony conviction expunged, and thereafter upon receiving the order, the TBI, a self-described fail-safe for the judiciary, decides that it's not going to comply with it, at that point, what happens if the person tries to register to vote or applies for a carry permit or serves on a jury? On the one hand, you have a judge issuing a final order restoring that person to the status that they occupied prior to their arrest, meaning that a judge has ruled that they can lawfully do all of those things. On the other hand, the TBI, an official government report, says otherwise and reports that the person has a disqualifying felony conviction. That will result in people being charged with voter fraud, being denied carry permits, and verdicts being overturned due to ineligible jurors. Any number of catastrophic consequences can result from conflicting official criminal records. That's the outcome that the TBI wants here. As for constitutional considerations, I want to emphasize two additional practical problems with the defendant's position that pose serious constitutional concerns. The first is that the harm that the TBI has wrought here is incurable, whereas here, a criminal defendant and the state of Tennessee enter into an agreement for diversion followed by expungement, then everybody does what they're supposed to do except for the TBI. The defendant has no mechanism to unwind what happened. Because the sentence has expired, the defendant can't file a motion under Rule 36.1, and because diversion is not a conviction, a defendant cannot file a post-conviction petition. As a result, there is no mechanism available to remedy this situation because nobody has ever even contemplated that the TBI would just sit back and intentionally violate a court order. The second is that the TBI's behavior here seriously undermines the integrity of plea agreements. Litigants can and do enter pleas based on agreements and advice about expungement eligibility. If you allow a non-party like the TBI to interfere with the terms of a party's plea agreement after the fact, like it is done here, though, then the plea itself becomes unknowing and involuntary. That is a serious problem. It's also one that the defendants make no attempt to address other than by saying that only a small number of people will be affected. Getting a little bit more abstract, Tennessee expects, and it is entitled to expect, other states and other courts to afford full faith and credit to our court's judgments. Astoundingly, though, an agency of the Tennessee itself, which is an actual party to the order in this case, refuses to do the same. Your Honors, that is outrageous and ought to be beneath the dignity of the Tennessee Attorney General's office to advise the highest law enforcement in this state to violate a court order. Your Honors, this court is often called on to adjudicate hard cases. I respectfully submit this is not one of them. This court should not mince words when issuing its opinion here. The TBI and its attorneys have to respect court orders. They are not above the law, and the plaintiff is not below it. The McNairy County Circuit Court's final and unappealed expungement order should be respected, and the trial court's contrary judgment should be vacated. Your Honors, if you have any additional questions, I'm happy to answer them.
All right, thank you, counsel. That concludes our proceedings for today.
The Honorable Court is now adjourned.